Thank you for coming by. This is American Project. Please be sure to like the video, and if you like this kind of material and these videos, please subscribe. Okay, this is part 2 of the documents from the court from the Fani Willis case. The appearance of impropriety is where we're picking up at. Finding insufficient evidence of an actual conflict of interest does not end the inquiry. Our appellate courts have endorsed the application when an appearance of impropriety standard to state prosecutors even without any explicit finding of an actual conflict. Certainly a conflict of interest or the appearance of impropriety from a close personal relationship with the victim may be grounds for disqualification of a prosecutor. A district attorney may not be compensated by means of a fee arrangement which guarantees at least the appearance of a conflict of interest. A prosecutor's close personal relationship with the victim in any case may create at least the appearance of a prosecution unfairly based on private interest rather than one properly based on vindication of public interest. In that case, the individual prosecutor who has the conflict may be disqualified. The cases cited here that resulted in disqualification did not hold that an actual conflict is a necessary prerequisite. The state, nevertheless, argues that the facts presented suggested as much, and while that may be so in some instances, the opinions do not make that finding, and this court cannot ignore the explicit language of the Georgia Supreme Court and multiple opinions from the Georgia Court of Appeals. Further, while Davenport is the first instance this court can find where the exact phrase appearance of impropriety is used to assess the disqualification of a state prosecutor, the reference to Caesar's wife in Nichols v. State and admonition against all temptation, suspicion in Godlin v. State demonstrate the principle has long been endorsed in Georgia law. While formally undefined in Georgia precedent, an appearance of impropriety is generally considered conduct or status that would lead a reasonable person to think that the actor is behaving or will be inclined to behave inappropriately or wrongfully. Borrowing from federal judicial recusal standards, a reasonable person is not an uninformed member of the public without only a passing knowledge of the facts at hand. This must be the standard, as otherwise, in this case, a casual, uninformed or misinformed observer might believe the district attorney must recuse herself merely because her father shares a last name with co-defendant. Nor is a reasonable person hypersensitive or unduly suspicious without an understanding of the relevant legal standards and judicial practice. The appearance standard recognizes that even when no actual conflict exists, a perceived conflict is the reasonable eyes of the public threatens confidence in the legal system itself. When this danger goes uncorrected, it undermines the legitimacy and moral force of our already weakest branch of government. Thus, it is that sometimes an attorney, guiltless in any actual sense, nevertheless is required to stand aside for the sake of public confidence and the probity of the administration of justice. This court finds that it can and indeed must consider the appearance of impropriety as a basis for a state prosecutor's disqualification, especially in recognition of the critical role that the prosecutor plays in the criminal justice system. One final observation can be gleaned from a careful study of our appellate decisions applying this standard. The remedy can vary. Unlike an actual conflict, the finding of an appearance of impropriety does not automatically demand disqualification. Our Supreme Court has previously analyzed disqualification under an appearance standard in a civil case using a continuum, recognizing that disqualification is not always the appropriate outcome. The Supreme Court further noted that disqualification due to an appearance of impropriety should rarely occur where there is no danger that the actual trial of the case will be tainted. When there is no claim that the trial will be tainted, appearance of impropriety is simply too slender a reed on which to rest a disqualification order except in the rarest of cases. Although the Court of Appeals found the existence of an appearance of impropriety, it noted that the appearance could be cured through screening the affected prosecutor from participation or discussion of the affected case. Moreover, to ensure that no conflict of interest or the appearance of one might develop, the district attorney took the prudent step of ordering the investigator to take no part in the investigation or prosecution of the case. These cases indicate that a trial court can consider alternative solutions to cure the appearance of impropriety. Nor would the finding of an appearance of impropriety on the part of the district attorney herself, in contrast to an actual conflict, necessarily result in a disqualification of the entire Fulton County District Attorney's Office. The district attorney in McLaughlin was absolutely disqualified due to a personal interest in the prosecution. As a result, assistant district attorneys appointed by the district attorney lacked any authority to proceed. McLaughlin did not address an appearance standard and made a point to limit the total disqualification to instances of absolute disqualification. When the appearance of a conflict exists, only the affected prosecutor, be they elected or appointed, is affected. The individual prosecutor who has a conflict based on at least the appearance of impropriety may be disqualified from participation in the case, but not all the prosecutors who work with him. With these principles in mind, the court finds that the record made at the evidentiary hearing establishes that the district attorney's prosecution is encumbered by an appearance of impropriety. This appearance is not created by mere status alone, but comes because of specific conduct, and impacts more than a mere nebulous public interest because it concerns a public prosecutor. Even if the romantic relationship began after Wade's initial contract in November of 2021, the district attorney chose to continue supervising and paying Wade while maintaining such a relationship. She further allowed the regular and loose exchange of money between them without any exact or verifiable measure of reconciliation. This lack of a confirmed financial split creates a possibility and appearance that the district attorney benefited, albeit non-materially, from a contract whose award lay solely within her purview and policing. Most importantly, were the case allowed to proceed unchanged, the prima facie concerns raised by the defendants would persist. As a district attorney testified, her relationship with Wade has only cemented after these motions and is stronger than ever. Wade's patiently unpersuasive explanation for the inaccurate interrogatories he submitted in his pending divorce indicates a willingness on his part to wrongly conceal his relationship with the district attorney. As the case moves forward, reasonable members of the public could easily be left to wonder whether the financial exchanges have continued, resulting in some form of benefit to the district attorney, or even whether the romantic relationship has resumed. Put differently, an outsider could reasonably think that the district attorney is not exercising her independent professional judgment totally free of any compromising influences. As long as Wade remains on the case, this unnecessary perception will persist. The testimony introduced, including that of the district attorney and Wade, did not put these concerns to rest. During argument, the defendant's focus largely pivoted from the financial concerns to disproving the testimony of the district attorney, namely that her romantic relationship actually predated the November 2021 hiring of Wade. On that front, the court makes a few brief observations. First, the court finds itself unable to place any stock in the testimony of Terrence Bradley. His inconsistencies, demeanor, and generally non-responsive answers left far too brittle a foundation upon which to build any conclusions. While prior inconsistent statements can be considered as substantive evidence under Georgia law, Bradley's impeachment by text message did not establish the basis for which he claimed such sweeping knowledge of Wade's personal affairs. In addition, while the testimony of Robin Yearty raised doubts about the state's assertions, it ultimately lacked context and detail. Even after considering the proffered cell phone testimony from defendant Trump, along with the entirety of the other evidence, neither side was able to conclusively establish by a preponderance of the evidence when a relationship evolved into a romantic one. However, an odor of mendacity remains. The court is not under an obligation to ferret out every instance of potential dishonesty from each witness or defendant ever presented in open court. Such an expectation would mean an end to the efficient disposition of criminal and civil proceedings. Yet reasonable questions about whether the district attorney and her hand-selected lead Special Assistant District Attorney testified untruthfully about the timing of their relationship further underpinned the finding of an appearance of impropriety and the need to make proportional efforts to cure it. Ultimately, dismissal of the indictment is not the appropriate remedy to adequately dissipate the financial cloud of impropriety and potential untruthfulness found here. Dismissal of an indictment is an extreme sanction, used only sparingly as a remedy for unlawful government conduct. There has not been a showing that the defendant's due process rights have been violated or that the issues involved prejudice the defendants in any way, nor is disqualification of a constitutional officer necessary when a less drastic and sufficiently remedial option is available. The court therefore concludes that the prosecution of this case cannot proceed until the state selects one of the two options. The district attorney may choose to step aside along with the whole of her office and refer the prosecution to prosecuting attorney's counsel for reassignment. Alternatively, Wade can withdraw, allowing the district attorney, the defendants, and the public to move forward without his presence or remuneration distracting from and potentially compromising the merits of this case. Forensic misconduct. The Georgia Supreme Court also recognizes forensic misconduct or improper comment by the state as grounds for disqualification. One example of such forensic misconduct is expression by the prosecuting attorney of his personal belief in the defendant's guilt. Finding pre-trial public comment that a conviction would be the right result constituted an impermissible but not disqualifying expression of the prosecutor's opinion concerning the merits of the case. As guidance, Williams instructs that the trial court should take into consideration whether such remarks were part of a calculated plan, evincing a design to prejudice the defendant in the minds of the jurors, or whether such remarks were inadvertent utterances. Williams also notes that while a prosecutor's comments may be considered improper, they must be egregiously so to justify disqualification. This court has not located nor been provided with a single additional case exploring the relevant standard for forensic misconduct, or an opinion that actually resulted in disqualification under Georgia law. Left unexplored, therefore, is how other examples of forensic misconduct can manifest, such as whether statements that stop short of commenting on the guilt of a defendant can be disqualifying. Nor has it been decided if some showing of prejudice is required, and how a trial court should go about determining whether such prejudice exists. Nor is it clear whether the analysis differs depending on the pretrial posture of the case. Unmoored from precedent, the court feels confined to the boundaries of Williams and restricts the application of the facts found here to its limited holding. The defendants have exhaustively documented every public comment made by the district attorney concerning this case through their motions and supplemental filings. Many of these have already been addressed through a pretrial challenge made on similar grounds brought by defendants Trump and Latham. This court incorporates and adopts the sound reasoning of Judge McAffee and finds that any comments made by the district attorney prior to July 31st, 2023 did not amount to disqualifying forensic misconduct. Public comments about the need for and importance of the investigation fall far short of the type of bias, explicit or implicit, that must be found. Similarly, more recent comments describing the charges in the indictment, the procedural posture of the case, the office's conviction rates, and personal behind-the-scenes anecdotes are not disqualifying. This includes the district attorney's unorthodox decision to make on-the-record comments and authorize members of her staff to do likewise. To authors intent on publishing a book about the special grand jury's investigation during the pendency of this case. Such decisions have an ancillary prejudicial effects yet to be realized, but the comments do not rise to the level of disqualification under Williams. The same cannot so easily be said of the district attorney's prepared speech delivered before the congregation of a local Atlanta church on January 14, 2024. In these public and televised comments, the district attorney complained that a Fulton County commissioner and so many others questioned her decision to hire Wade. When referring to her detractors throughout the speech, she frequently utilized the plural they. The state argues the speech was not aimed at any of the defendants in this case. Maybe so, but maybe not. Therein lies a danger of public comment by a prosecuting attorney. By including a reference to so many others on the heels of defendant Roman's motion, which instigated the entire controversy, the district attorney left that question open for the public to consider. The court finds, after considering the statement as a whole under all circumstances surrounding its issuance, that the district attorney's speech did not include defendant Roman and his counsel within its ambit, whether intentional or not. More at issue, instead of attributing the criticism to a criminal accused general's aversion to being convicted and facing a prison sentence, the district attorney ascribed the effort as motivated by playing the race card. She went on to frequently refer to Wade as the black man, while her other unchallenged special assistant district attorneys were labeled one white woman and one white man. The effect of the speech was to cast racial aspersions and it indicted defendant's decision to file this pretrial motion. However, the speech did not specifically mention any defendant by name. Although not improvised or inadvertent, it also did not address the merits of the indicted offenses in an effort to move the trial itself to the court of a public opinion. Nor did it disclose sensitive or confidential evidence yet to be revealed or admitted at trial. In addition, the case is too far removed from jury selection to establish a permanent taint of the jury pool. As best it can divine under the sole direction of Williams, the court cannot find that the speech crossed the line to the point where the defendants have been denied the opportunity for a fundamentally fair trial, or that it requires the district attorney's disqualification. But it was still legally improper. Providing this type of public comment creates dangerous waters for the district attorney to wade further into. The time may well arrive, or may well have arrived, for an order preventing the state from mentioning the case in any public forum to prevent prejudicial pretrial publicity. But that is not the motion presently before the court. The defendant's motions demanding disqualification and dismissal based on forensic misconduct are denied. Other grounds. The defendants invoke a range of other constitutional, statutory, and county provisions in support of disqualification, including Georgia Constitution, Article 1, Section 2, Paragraph 1, the trustee clause, various provisions of the Fulton County Code, including financial disclosure requirements and alleged payment and hiring violations pursuant to OCGA, 15-18-20. As to the latter, a district attorney may appoint private attorneys to assist with criminal cases independent of any specific statutory authorization. This statute does not place limitations on the appointment of a special assistant district attorney to work on a specific case as opposed to county approval of a general employee. While Wade's contract did not limit his work to any particular case, the testimony established as much, and the defendants have not produced any evidence demonstrating that his work ever expanded beyond this prosecution. Further, to the extent the defendants argue the circumstances of Wade's loyalty oath create independent grounds for disqualification, the court incorporates its previous order on the subject and denies the motions. As for the remaining provisions and arguments, the court has not been presented with any authority that such violations, even if proven, amount to an actual conflict of interest, nor that an appearance of impropriety can apply to any instance of inappropriate or wrongful behavior. In each case, applying the appearance standard, the impropriety was connected in some way to an allegation of a potential and previously recognized actual conflict. In a separate motion adopting the arguments of her co-defendants, Defendant Latham presents an additional theory. She asserts the right to call a district attorney as a witness at trial to examine her biases toward the defendants and demonstrate that she brought a politically motivated prosecution. Accepting a sole citation raised in support requires ignorance of the opinions surrounding context. Actually reading the case and the authority upon which it relies, and not simply quoting a head note, reveals that the Court of Appeals' antiquated use of the word prosecutor referred not to the legal officer handling the criminal case on behalf of the public, but rather the main witness for the state. Defendant Latham asserts a claim accurately categorized as one of selective prosecution, and the United States Supreme Court has recognized that such claims are not a defense on the merits to any criminal charges themselves. Instead, a claim of selective prosecution must be brought in the form of a motion asking the trial court to exercise its judicial power on equal protection grounds. Lacking such a showing here, or any foundation in law or the rules of evidence, the motion is denied. Conclusion. Whether this case ends in convictions, acquittals, or something in between, the result should be one that instills confidence in the process. A reasonable observer unburdened by partisan blinders should believe the law was impartially applied, that those accused of crimes had a fair opportunity to present their defenses, that any verdict was based on our criminal justice system's best efforts at ascertaining the truth. Any distractions that detract from these goals, if remedial under the law, should be proportionately addressed. After consideration of the record established on these motions, the court finds the allegations and evidence legally insufficient to support a finding of an actual conflict of interest. However, the appearance of impropriety remains and must be handled as previously outlined before the prosecution can proceed. The defendant's motions are therefore granted in part and denied in part. Okay, there you have it. Thanks for coming by. Please be sure to like and subscribe. I really appreciate it, and have a great day. God bless.